first experience that I can recall right now was when I was in law school. First experience with housing discrimination. My wife and I were living in Buffalo, New York. We were looking for a place, had a young daughter, and my wife, who was from Lansing, Michigan, I tease her all the time because I says, when you're on the phone, you sound like a white woman. So she calls and gets an appointment for us to see a place in Kenmore, New York, just outside Buffalo. Very nice community, well manicured lawns, you know, where you'd really want to live. And I didn't want to go because I'm from Detroit, she's from Lansing. Lansing, by the way, is one of the most integrated, or was years ago, one of the most integrated communities, at least in Michigan and probably in the country. And I'm from Detroit. I knew about housing discrimination. She didn't. Oh, Kenmore's a great place. I read all this stuff. Let's go. And it was a reasonable price. Mind you, we're students. So we get there, and we get up on the porch, and the owner comes out, opens the door, looks at us, and my wife says, "We're here to see the apartment." "Nope, not for rent." Closes the door. I said, "See, I told you. Let's get out of here." But my wife was just so outraged, and I really got a little angry with her because I told you before we came over here, this wasn't going to work. So we went and we filed a complaint with the local Office of Discrimination, which, to my amazement, said if the owner lives in the property, then they can discriminate. Well, I didn't think that was a law. I was sure that wasn't the federal law. But we were students, and we just moved on. Nothing else became of it. After I became a lawyer, I met Mike Ocean. And Mike says to me, "We need lawyers over in the Fair Housing Center." So I volunteered. And interestingly enough, most of my most interesting cases with the Fair Housing Center have involved interracial couples. And for some reason, realtors, landowners, whomever it is, seem to get more irritated by an interracial couple than they do by a black couple. One of my recent cases, we had a couple that was, again, the wife made the call. The wife was the white woman, made the call, and the realtor made an appointment. And the owner was an owner of a huge number of properties. So the husband and wife go for this appointment, and they walk in, and the owner looks at the husband and says, "Who are you, her driver?" No. Well, needless to say, both of them at that point knew this deal isn't going to work. And so the owner says, "Well, you can go see the house and look at anything you want." After they got through looking at the house, which was being advertised in the free press and continued to be advertised in the free press, he tried to sell it to his son. Then he tried to sell it to a friend. He finally sold it on land contract to a woman who was on assistance, all to avoid selling to my client. We filed a case, of course, brought the case. Fortunately, when his lawyers saw the case, they decided there was nothing to defend. Unfortunately for us, they only had a $100,000 insurance policy. So they offered up their policy. They had nothing else. We took it. Two things about that story. Number one, always look for some insurance. It's there somewhere. I think, I forget her name now, the tester said that the owner, Natalie, said they were crying broke. Well, my guy couldn't cry broke. The defendant in our case couldn't cry broke, but he was cash poor. But he had insurance. So you always look for insurance. Secondly, you ought to be outraged at what you encounter in these cases. This is not just a violation of the law. This is really an insult to humanity. You got people who have the ability, the wherewithal to transact, to make real estate transactions, to buy property, to rent property, to live here, to live there. there's no good reason why anyone should be able to say, I don't like who you married, or I don't like where you were born, or the color of your skin. That simply doesn't make sense. So every one of us ought to be outraged when we encounter discrimination. I think back on my own situation with my wife and how I wasn't outraged, but she was. Well, I'd been through it before, but I should have been just as outraged as she was at that time in Buffalo when the owner slammed the door in our face. Just a total insult. Remember something else. John said that he rarely files in state court. I never filed in state court. These are federal cases, and quite frankly, there's a prestige to prosecuting a federal court case. It is a federal case, and that means something to people. That gets the attention of whom you are suing. And don't apologize for bringing the action, because you're within your rights, and you need to be doing what you're doing. What I want to do, though, is talk a little bit about the practical aspects of filing a case and seeing it through to trial or settlement. Something we don't see a lot, we don't talk about a lot. The first thing I say is, when you think that you're going to file a case, even for your investigators who are investigating cases and you want to determine what is there and what isn't there, I always start from the back. I start from the back of the case and I work my way up. When I get a case, Mike calls me, we got a case, we got this, we got that. First thing I want to do is find out what kind of case is it. Is it rental? Is it purchasing? Is it financing? Once I determine that, then I go to the jury instructions. And I say, what are going to be, what's the judge going to say to the jury? These 6 or 8 people who know nothing about the case, may not have any expertise in this area. What's he going to tell them that they have to look at, think about, and what they must find in order for me to prevail? So I want to know what the judge is going to say. Now, as a litigator, we also all know that before you get to a jury, you get the motion for summary judgment. Every case, no matter how strong your case, it's coming. Although in the last case, the one I was just talking about, they didn't file a motion. Unique situation. So you also have to look very closely at your recent Court of Appeals decision. Now, the Sixth Circuit publishes all of its opinions. You can go online and get all their opinions and find out exactly what's being said, what the decisions are, published or non-published, coming out of the Sixth Circuit these days. We're fortunate in that we have a Sixth Circuit that I think applies the law and applies it correctly. That doesn't mean we win all of our cases, but that does mean that we know going in what to expect. After I've done my legal research, my jury instructions, my summary judgment standards, the next thing I want to do is I want Mike to tell me who the testers are so I can meet personally with the testers. Now, I heard John say that he called his tester on the phone, but that was for a motion. That's quite different. If you're anticipating, and most of these cases are hotly contested, they're really litigated. People, just like John just said a minute ago, a lawyer still said, you're calling a judge a racist. That's right, we're calling a judge a racist. That's not like saying something about your mother or anything like that. People take that to heart. And so you're gonna fight. You're gonna fight in this case. You're gonna have a knockdown, drag-out fight in this case. They're gonna try to embarrass you. They're gonna try to insult you. They're gonna try to frighten you. Who's gonna be on your side? Who's gonna support you? Who's gonna back you up? Who's gonna save you from humiliation? Oftentimes, it's the tester. So I always want to meet the tester in advance. Before I even file the complaint, I want to see the tester, talk to them, know who they are, size them up. And the reason I do this is because I also apply the same types of standards to the client. people who get discriminated against often get picked on because they are a good discriminatee. They are someone who you can look in their eyes, you can frighten them away. I can tell him to go to hell and he'll try to get there. It's what some people think when they're in the process of discriminating. So you need to know who you're working with. I've had clients who have ended up being like a deer in headlights when it's their turn to testify. In your office, they're magnificent. They can tell you verbatim what has happened. They can detail it. They can remember it like it was 30 seconds ago. But once they get on that witness stand, something happens and they lose it. And once they lose it, they've lost everything. They just wilt on you. So you really got to know who you're working with. I always also collect my exhibits. Now this is what I try to do. I don't always do it. I'm not always successful. Sometimes you've got deadlines that you have to meet. Sometimes you're working on other projects and you have to go ahead and file and then follow up. I try to collect my exhibits ahead of time. I want to know how can I win my case before I know what their defense is to my case. I know I'm going to have to make an adjustment when I hear what they're saying. But before I go in, I want to know, how am I going to win this case? What am I going to use to prevail? So I try to get all of that, and I don't put it in the complaint, by the way. And I think it's best that you don't lay out your entire case in the complaint. I think you want to plead your legal theories and some facts to support them. But discovery is when you find out exactly who is who and what's what. So I draft interrogatories. I get my exhibits together. Fair Housing always has a boilerplate set of interrogatories. They don't usually work in every case, but they give you a very good framework for where you begin and what kinds of things you start looking for. And then I really work on my client, and I try to see just how strong a witness my client's going to be. Because my theory is, in every case, I want to minimize, keep my client on the witness stand for the shortest time possible. Because a good cross-examiner can destroy any witness. And there have been some good ones. I had a, divert a little bit, I had a office partner. He's passed on now. He used to drink a fifth of scotch every morning. He'd get in the office about 6:30, 7 o'clock. He'd have his fifth finished by 7:45. He's on his way to court. He could cross-examine the most skilled, the most polished witness. I don't know how he did it. I don't know if the alcohol helped or not. but he was great at it. And one of the things he taught me was, if you leave a person up there long enough, they're going to stumble. They're going to forget the script, and they're going to start pouring out what you want to hear. So I always remembered that. My clients, I want them up there, I want them to tell their story, and I want them down. So you want to minimize that. John talked about the Rule 26 conference in federal court. You're going to have some kind of conference before the federal judge where he sets a discovery, he or she sets a discovery schedule, tells you when and what's going to be done. To me, the most important part of that conference is to get to know the judge's staff. I think Heather will probably agree with me on this. When you can call up a staff member and say, Heather, instead of Miss Clerk, we're running into a snag and we need 2 extra weeks to complete discovery. What do you think the judge is going to say? And she'll say, oh, I'll talk to the judge, and the judge will, I'm sure the judge will agree with that. Or, no, the judge is not going to agree with that. And that's what you want to hear. Whether it's yes or no, you want to hear it, and you want to know the staff person well enough that you can have a casual conversation that puts you on notice. I better get moving, or I got a little more time, or whatever the situation is. ultimately, you come to trial. To me, one of the most important things about a trial today is to try to understand the attention span of the jurors. Very short, okay? They're not going to consume a lot of information back to back. So you want to get in there, you want to be concise, you want to put on your proofs, and again, I mean, I can tell you a story about a juror. We were reading depositions, doctors' depositions, which was really the worst. And today, every chance I get, I'll pay a doctor extra to come in live. Because when you read a doctor's deposition, at least one and maybe two of your jurors are going to go to sleep. And I don't mean nodding off. I mean sleep. And I was in Oakland Circuit Court, and we read the doctor's deposition. And finally, the judge had to stop us because you really couldn't hear the witness because one guy was snoring. I mean, it was that bad. Not their fault. It was after lunch. And you know how we do after lunch. We nod off, we go to sleep, but he was snoring. So you got to understand what their attention span is. I mean, these are all these dynamics that go into a trial that aren't on paper. You know, they don't, I mean, you know, you look at your case on paper and you got a perfect case. I mean, it's excellent. But if it's too long or too boring, you got a problem. You want to take your exhibits, the ones that you've collected already, and you want to get those marked and you want to get those identified before your trial starts. Jury, the judge calls a case. Judge, I offer exhibits, or even before they even calls a case. A lot of judges now will let you mark your exhibits in a pretrial conference, after which you'll go on the record and say these exhibits are marked, they're admitted. You at least know which ones are not in contest. Once that happens, you're free to use your exhibits in opening statements. And I recommend that you do use a PowerPoint, so that, or you make a copy of the exhibit for each and every one of the jurors in a folder that they can have at their seat. I mean, I know we like to blow up things and have the poster board, but if they got it right there in front of them, it makes it so much easier for them to follow along as you're describing your case. So you want to use your exhibits in opening, you want to make it available to each of the jurors, and you want to be as succinct as you can in the presentation of the evidence. Cut out the fat, cut out the extra, because that's your time that you're using, and you might alienate or lose the person you're trying to win over. I didn't talk about settlement discussions, but yes, Heather.
I was just wondering, since you're on the topic, time limits in civil cases. Have you experienced those yet? Our judge has been using them pretty consistently, as are several other people in the Western District. Is that something you're seeing?
You don't see them in a formal way over here. What you do see is a judge will say, "Move on, counselor." They've been doing that forever.
I've had it in a couple cases.
I welcome it, because I really do believe that my client's exposure is more damaging than all of the things that they could say. All of the global things that they could say might be helpful, but in all likelihood, they're going to hurt themselves more than they help themselves the longer they're up on the witness stand. So anytime a judge tells me you've got 10 minutes, I say thank you. That's how I use it. Settlement discussions. Stay in touch with the Fair Housing Center when you have settlement discussions on a fair housing case. The resources they have related to the value of a case is tremendous. I never would have settled that case where they offered policy limits, because you know my chest is stuck out and I'm rolling, and I really did a good job of cross-examining this defendant, if I don't say so myself. So I was ready for the trial. I wanted to, you know, do a little sparring. called up Cliff. I said, Cliff, they're only putting $100,000 on the table. And Cliff says, what? Are you crazy? Take it. You should have taken it when they said 75. Oh, Cliff, okay, all right, you burst my bubble, you know. But as it turned out, my clients used that money to buy a co-op right around the corner from where the house was that they should have bought and should have paid more for. So it ends up that the discriminating landowner ended up buying a very nice condo for my clients, and they love it. They love it today. So that's always gratifying. The other thing is, when you're working with the Fair Housing Center, I know Mike is going to remember this one. Don't give the other side a non-disclosure clause. Years ago, I mean, it's almost standard in your other civil cases. I don't know what I was thinking about. I know what I was thinking about. That was another big settlement, Mike. We had a real good settlement on that case. That was out in Warren, where a black guy went out and he made a full price offer, and he worked at the Warren Assembly Plant so he could walk to work every day. He really wanted this place. Well, they took one look at him and says, well, you know, no, I don't think so. But I'm making a full price offer. No, I don't think so. So the next day he gets his buddy at work, who's a white guy, to go in, use his name and make the same full price offer. So they're drawing up the papers, and all of a sudden the seller says, wait a minute, don't I recognize that name? He says, I think a black guy came by here the other day and that was his name. So naturally the deal fell apart. They then sold the house to the next door neighbor's son or something or another, and we ended up again prevailing on that case. But in that case, without thinking, the realtor says, look, this will ruin my reputation, so I need a non-disclosure clause. I said, okay, I don't care. Well, the fact of the matter is, one of the ways you stop discrimination is to let everybody know how much money folks had to pay when they engaged in it. It is a deterrent. It is a real deterrent. The other thing is, the Fair Housing Center has a newsletter, and they need to let you know what's going on. And the other thing is, funding is improved. The opportunity to fund cases is improved when you have successes. So don't ever make the mistake I made. Don't ever give them a non-disclosure clause, which means you can't tell anybody that you just beat them into submission. Just a few tips. She's walking, so there's just a few tips to let you know, and if you have any questions, you can come and see me afterwards.
Thank you.